So this is a nice wrap-up session of our concurrent panels. Each of us was, of course, only in one of them. So here's the opportunity to get to know what transpired in the others. So the way it's structured is that each one of the persons chairing those different concurrent sessions is going to make a short presentation of up to 10 minutes. I'm going to request all the persons here. We have a timekeeper who will show you 5 minutes, 2 minutes, and then finally time's up. And after that, there would be 10 minutes Q&A. So let me begin right away. Our first concurrent panel was looking towards the future, which is relating to the right to land. And in turn, I'm going to ask Justice Ramasubramaniam, followed by Professor Michael Lipton, to please make. You are free to either speak here or there.
We've been accustomed to sitting and speaking for quite some time. You know, the days when we stood and spoke have gone 10 years ago.
So the timekeeper is requested to show the card here.
Actually, we had a very interesting session. I could say that the discussions revolved around three different areas. One, the reforms that were needed in the legal education, how to teach land laws to students, what to teach them, how to teach them. That was the first area of focus. The second area of focus was the legislative reforms. But there were contradictory views, conflicting views. One view was that there is a plethora of legislation which had to be unified. Other view was that it can't be done. Then the third area of focus was as to how to ensure who are the public that we are talking about. When the acquisition laws talk about public, who are those public? Whether the public are those who did not have lands for whose benefit the lands are sought to be acquired, or whether the persons who own land are also come within the meaning of the word public. These are the broad areas, I think, around which the discussion in our session turned around. Let us take, for instance, the first issue, the reforms that people wanted on legal education. Many of the speakers in our session said that we teach in law universities. We had three professors who were teaching, apart from Amita, there were three persons who were teaching land laws or some other subjects in law universities. All of them said we teach procedural laws in law universities. We introduce students to substantive laws like land acquisition, central legislation, state legislation, etc. Whether we should continue to do that. Is that the module that should be available to students to know? The acts are there for people to see. Even students can go to the library and find out. Is that the objective of teaching land laws? What is the kind of material that we produce? In fact, in response to this, one interesting observation came from a past student of this university who is now working in the field. He said, there are people who want legal assistance, but we are not getting, despite Legal Service Authority providing so much. The real problem was about 30-35 years ago when legal aid started. It all started as a pro bono. But today, the legal service authorities are paying a retainer to the lawyers, and we are also paying on a case-to-case basis, but still we are not getting lawyers who could take up the causes of these people. So what should the legal education focus? Should they teach these statutory enactments, what the Supreme Court said, what the High Court said? Should it be law-centric, or should it be people-centric? Then the discussion was that it could probably shift from being law-centric to people-centric. You can teach laws with respect to, from the perspective of the landowner, from the perspective of a person who is in lawful occupation of land, person who is in occupation of a land without any right whatsoever conferred by anybody, and people who are migrants who keep moving on. If that is the way law is taught, probably it could, that is one of the suggestions that emerged insofar as the reforms relating to legal education is concerned. The second area of concern expressed was about legislative reforms. On this, we had completely divergent views. One view was, for instance, one of the persons said that in the state of Telangana and Andhra Pradesh, there are 112 enactments dealing with land laws. Should there be 112 legislations? Should they not be combined into one unified code? That was a suggestion that emerged. But then there were the opposite views. Many people said, no, there can't be one single unified code because either at the central level or at the state level, we have coastal areas, we have forests in some states. Even within the state, you have, for instance, Andhra and Telangana, there are coastal areas and there are forest areas. Therefore, they said you can't have a unified code because when you attempt a unified code, you leave out somebody, you leave out some areas. The land itself is classified into urban land, arable land, wasteland, forest land, coastal land, etc. If all of them have to come in one compendium of one code, it's not possible. Therefore, we couldn't arrive at a consensus on that. That was the second area. The third area was with respect to what to do with these land reforms. What happened to, we have had the experiment of land reforms for about 40 years, but what happened to the land acquired? Where has it gone? Has it really reached the people for whose benefit they were all acquired? That was the third area of concern that we talked about. In fact, Professor Lipton said about 30 years ago, 70% of the population in India depended upon agriculture. But today, people who depend upon agriculture is about 40%. Therefore, reforms in law more easy, according to Professor Lipton. These are the three broad areas around which our discussions focused. I'll now leave it to Professor Lipton to take over.
Thank you very much. Justice Subramaniam has dealt with most of the important issues. I'll try and mop up. I think a lot of our discussion was about documents and records and the need to get into the hands of the tiller some sort of document specifying his right in land. It was suggested to us that something like half the farmers in India did not have a proper document showing the right in land. We then came to the question of just what document that would be, especially in view of the fact that there are a lot of tenets about of what exactly does their right consist. The word sharecropper wasn't mentioned, but the problem is even more acute in respect of just what rights those people do and don't have. But certainly the lack of a document is a quite serious problem, the lack of a clarity about title. Now, this, of course, feeds into a worldwide controversy, because many people say that titling is a weapon of the strong against the weak, that the strong gather up as many titles as they can and use them to get rid of the weak who don't have titles. Others say the very opposite, that a title is the best protection for the weak against land alienation from them. Another issue that we didn't really tackle under the question of title is the small minority, but still a large number of people in India who are holding land under some form of communal or other non-private tenure. What sort of document can they have, and what sort of conflicts exist that a document would help to resolve? Second, there was quite a lot of discussion about the right to land and what that means. I just want to make two observations. One is that there are a number of countries, South Africa, for example, which have a specific category of agricultural lands. And to agricultural lands, different rules apply, both for takeover and for compensation, and for what can and cannot be done under a reform law. A whole lot of things are special to agricultural lands. And, of course, this does lead to disputation between ministers responsible for land reform and ministers responsible for agriculture. They often want almost opposite things, but it's a problem. But there are certain things that are resolved by having a special category of agricultural lands, which is the land which is a source of actual livelihood. Now, that also raises the wider issue, which has been also raised in plenaries, of whether we ought to be talking of a right to land or of a right to work, or rather whether we should be talking of a single right to citizenship, citizenship conferring claims on life, claims on liberty, claims on protection by the state, and so forth. And that this single right of citizenship has implications in each of the special fields that we are looking at. Now, in the field of land, and particularly agricultural land, that would be the capacity of a person to fulfill one of the requirements of citizenship, namely dignified access to a decent livelihood, which in an agrarian society depends on some access to land. And it was in that context that I made the remark that that task via land reform has been made easier because there are now not so many as a proportion of the population engaged principally in agriculture. And I would add that of those who are engaged principally in agriculture, a larger proportion, and indeed now probably a majority, are part-time farmers, in the sense that at least 1/3 of their income, often much more, is coming from non-agricultural sources. So that the amount of land needed to make these people up to some sort of basic minimum is a good deal less than it was in the truly contentious days of land reform in the 1950s and 1960s. Further, the position of the rural rich, and of the rich more generally, in respect to agricultural land, may in some cases have become less dogmatic and contentious, because the portfolio of rich people in India, and indeed in the world as a whole, is not so centered on agricultural land as it was, let's say, 30, 40, 50 years ago. Therefore, there are perhaps a smaller proportion of the population who are poor people, less dependent on agricultural land, and the large farm holders less concerned with agricultural land as the main component of their portfolios for which they will fight to the death. Against that, it needs to be said that there is also a much smaller proportion of land in large holdings. It's now getting down to 11%. You go back to the 1950s, you're getting 25, 26%. So there isn't as much agricultural land to distribute. That makes it more difficult. But the situation with regard to rights to land and capacity to meet those rights of the system is fairly crucial to the question of whether one now ought, as a pressure group, whether an academic or an activist, to be going for land reform. Third, the question of teaching of land law. Now, this is something on which I'm completely unqualified to judge, and therefore I can sound off. I'm neither a lawyer nor a teacher of lawyers. But I did detect a very clear conflict of aims here. You both want to get lawyers out of the system who are good at, out of the educational system, who are good at and knowledgeable about defending and supporting litigants in land cases, especially, one hopes, poor and needy litigants, not just the rich litigants. But anyway, you need to get that out of the law education system. So you want, and I heard quite a few people saying this, to stuff in more and more detail of land, of particularly of state, but also central land law. On the other hand, you also want lawyers who understand what land is and what it's for, and who uses it, who is made strong by it, who is made weak by it, who needs it for a livelihood. And that requires some understanding of the economics and sociology of land. Sorry. Now, there's a conflict between those two. You can't stuff everything into one course. And resolving that conflict is obviously a major issue for you. Obviously, I, as an economist, would come down strongly on the side of saying people do need to know the effects of different land laws when they're considering them. And that brings me back to what I was saying yesterday about incentive compatibility. Because the way a land law is interpreted in the courts can itself make a great difference to the incentives that it provides, and therefore to the results, including the results for the poor. That, of course, is a way in which the question of what you teach relates back to the question of whether you think you're teaching about land rights or about citizenship rights reflected in land. So these three aspects of our discussion are held quite closely together.
Thank you. I think all of us who missed those sessions, wonderful insight into the key questions, both curricular and in terms of the way in which legislative reform should take place. Can I now request Justice Muralidhar to summarize what happened in this session? This is the session on right to housing.
We had a very useful discussion and very insightful. For me, it was coming back to what had been missing from my lawyer days. We began with looking at what kind of protection would a right to housing offer and against what forces. We were discussing this instance of people being forcibly evicted because they protested. In Noida, in Greater Noida, there was a new housing complex that had come up, and a domestic help had been restrained by her employers. And the her family and those supporting them went into the housing complex to get her rescued. And as a result, the backlash was that the entire basti got removed, the entire basti from where these workers came. So one issue was, what are the kinds of housing that we are talking about? Whose rights are we talking about? And what forces are to be resisted? We also had a presentation on the issues of exclusion, expulsion, and discrimination when it comes to the context of urban homelessness. So many speakers reflected on urban homelessness actually being an expensive thing, because everything that you do on the streets, whether to take a blanket, to find a space for yourself where you can have an undisturbed sleep, whether you can use the toilet facilities that are available, all of that is paid for. And to understand homelessness to be something which is free is completely contrary to the reality. And a variety of reasons bring people onto the streets. Children come to the streets because of violence at home. Women are subject to indiscriminate and disproportionate domestic violence that drives them to the streets. So when you talk of a right to housing, you have to acknowledge the right to live with dignity, the right to live with security, and to understand the role of the state. So state uses law as an instrument to expel and exclude. Typically, for instance, you draw zones of legality and illegality with the instrument of law. And then that is deployed with disproportionate force. So one comment was that the state is actually at war with the poor and uses the instrument of law to actually deprive them of their basic rights of survival. So the state views itself as enforcing the law for legitimate citizens against those who are considered by the law to be illegitimate. And a discussion was also on what happens when you take these issues to the court. So typically a discussion on the right to shelter in the context of night shelters. So the group felt that the courts are not responsive enough to the voices of the poor in this context, where the poor have to demonstrate before a court that they have legitimate grievances, they're genuine, they're bona fides. And this democratizing the space within a court for this issue to be deliberated needs to be worked on. On the aspect of exclusion and expulsion, it was seen as a class issue as well, where people of a dominant class, typically a resident welfare association, would get together and go to the court and ask for removal of a slum. And what happens when you draw zones of legality? So those people who feel that they're within the zones of legality might consolidate and say, well, we want to exclude people who are not within the zones of legality. there was a need to look at the micro level, requirements depending on what the housing needs are. For a rickshaw puller, for instance, in Delhi, the rickshaw is the place where he rests. So he doesn't have a permanent place or address. And this so-called address becomes very critical for him for a bundle of other rights, as it is for a variety of citizens, that if you don't have a permanent address, you don't have an entitlement to rations, you don't have an entitlement to be on an electoral roll. So the address becomes the most critical thing for a variety of rights. A school will not admit a child who does not have an address. So this is something that the right to housing will have to acknowledge. The other issue was about, again, in the context of Gujarat, where there is a Disturbed Areas Act, which I had not heard of, but which is now being used to ghettoize and segregate populations. So what was meant to actually, not segregate populations is actually being used today to segregate populations. And in this context, the discussion was on the master plan, which is a legislation which identifies areas within a city for specific purposes. So it also identifies areas for economically weaker section housing, but which is not utilized for that purpose. So how many of these elements of a right to housing can go to change a master plan, and what should be that process, and how to democratize that process? I think there are several paradoxes here which we discussed. One was the local versus the national, the local versus the national versus the international. So how many of the international perspectives, like for instance the South African perspective that we have on the right to housing, how much of that informs the lawmaking process in India or the behavior of courts? Will the courts borrow the law from other jurisdictions when they interpret the right to housing in the Indian constitutional context? The paradox of the institutions themselves. How democratic are the institutions which deal with the issues of recognition and enforcement of housing rights? Can we actually have public participation and what we call as deliberative democratic practices? The South African courts have experimented with meaningful engagement, where the government is asked or the local authorities are asked to actually have consultative meetings with the population that is affected. And it is only after a court order prior to the eviction which permits the eviction that the eviction can take place. What challenges does that throw up, and how much of that can actually inform the kind of laws we want to make? And because it's recognition of a bundle of rights, should we not give enough flexibility for local issues to be addressed depending on the place where the need is felt most and the population which is to be addressed? There is also a law and economics issue here, because as much as there is a cost of legality, there is also a cost of illegality. So we need to understand how the parallel processes work too. If you have a security of tenure of any kind, can that be traded? Can that be, monetized? Because you don't have meaningful, relevant housing. I'm talking in the context of Delhi itself, where the relocation of slums is at a distance of 40 kilometers outside the city, where people working within the city will not have any incentive to take the alternative housing. And yet, because it gives them some security of tenure, would want to exchange it for some other place within the city, which again is illegal. So the law and economics issue was also one of the points. And of course, the impact that such a right to housing would have on a variety of institutions, actors, and the way we organize ourselves. I think we just understood how complex, when we talk of a right to housing, how complex the issue is and how it has to be addressed at various levels. What are the paradoxes in making it into a constitutional right, a statutory right, and the dangers of exclusion, expulsion, and discrimination. Thank you.
you know, the fact that these rights can also be fungible and can be traded, I think that's something quite new that was brought onto the table. Can I now request Justice Jayamala Baxi to please make the presentation of the panel on the right to work? Thank you.
Good morning. The right to work discussion began with a very interesting take. When we began our discussion, the first speaker said that I'd like to speak about right at work rather than right to work. And I think he was very correct. The right to work has a mixed heritage. At times, right to work has been used as a weapon of independent choice in contradistinction to collective bargaining. And so we decided to discuss collective bargaining vis-a-vis right to work. And the discussion panned out in this manner that the constitutional imperatives of equality and the access to justice are perhaps not so articulately brought down to the statutory scheme work of things. Although we speak of equality of employment, particularly public employment under Article 16, and we have equality of justice and social and economic justice in the preamble, the Industrial Disputes Act, which provides for collective bargaining along with the Trade Unions Act, is restricted essentially to the organized sector. And that we discussed, and it was about 3% of the entire working population of the country. So in effect, a constitutional and at times a fundamental right of right to collective bargaining and the right to equal treatment at work is statutorily secured by a scheme of adjudicatory mechanisms and conciliatory schemes only to a 3% of the workforce in the country. Rest 97% are left out from the just and humane conditions of work, which perhaps should be read along with the right to work as enshrined in Article 39E and Article 41 of the Constitution. So the discussion and the panelists stressed that the organized labor's rights of association and the rights to form collective bargaining unions should be extended to the unorganized sector, and the new legislation which has been proposed in this area leaves much to be desired. It is also, we've also discussed on the idea of not keeping the discussions within the four corners of this elitist echelons, but to bring it down to the real working fields where the workman meets the employer and bargains for his rights. And that is where the action-based studies through these universities are so important. And there was a proposal that the results be widely circulated, brought to the table of the various organized working collective bargaining forces, so that they are able to cite the results, statistics, and be at a more informed and effective preparedness in the processes of negotiations for better rights. It was also a matter which we discussed, the maladies which prevail in the public, the organized sector bargaining areas and the collective bargaining areas, the inter se non-convergences, the conflicts, and the partisanisms which arise out of more ulterior interests to be borne out through labor battles and labor conflicts on the political domain, rather than seeking the rights of the workman as an end in itself. In other words, the rights of workmen in collective bargaining fields become means of achieving political power and not an end in itself. That was also brought to light and discussed. We discussed the trade union movement in Maruti factory, and also the issues how the trade union movements require to be more invigorated on the planes of collective bargaining rather than judicial adjudication, keeping in mind the inordinate delays which take place in law courts. The more interesting area was kept, issue was kept for the next panelist, who dwelled upon the idea of universal basic income and its impact on right to work. We was plagued with series of questions that is it eclipse of the right to work or a substitute for the right to work?
I can speak for this group at least, but we've come here to learn and unlearn many things. All your comments, your criticisms are well taken. But having said so, a couple of things that I want you to keep in mind, which is what I told the discussants also, and since we have a larger audience here and the others were not there, that giving up on courts is not a good idea. It's a partnership that you need, and it's a partnership that you must nourish and irrigate. It's no point saying that, we are not doing enough, because there is always, to use the expression of my friend Mander, that there is that one blip, and but that doesn't count for all. That one blip is important because the Supreme Court, and I'm speaking in the context of those who were here yesterday, that the Supreme Court has a chance to revisit its view only if there is that one blip in the High Court or the Law Court. So please don't give up on courts. As I said, you have some, excellent members on my left who done some great amount of work. Now, insofar as our panel is concerned, now, I read this beautiful phrase in, I think it was Dr. Sean's presentation, where it said, education is a bridge to all rights and learning knows no bounds. Everything that preceded me is actually dependent on where we go, where this is concerned, which is right to education. And if we don't have education, then believe you me, you will not have other rights, because the state is stone deaf. It won't respond unless it's prodded. So having a beautiful statute by itself doesn't help, but giving up again on the statute is also not a good idea, because if anyone needs to enforce something through a constitutional process, which I think is the appropriate process, is through a statute which is robust and takes care of all that we require to have. So in our panel, what was brought out was the gaping holes that we have in the statute and which we need to plug. Now, there are ways and means of doing it. There are certain things that courts can do, which is, if there is, as Denning would say, and Justice Baxi would, Professor Baxi would know, I would actually count you as a justice, or a jurist, for all the knowledge that you've given the youngsters who are on the bench today, is that you can iron out the creases, but you can't plug which is not there at all. So what was brought out was that for children of the age group from 0 to 3 and 14 to 18, there is nothing in the statute. Now this is something only you can do. You can sort of agitate in a civil way and bring it to the notice of those who legislate that we need to plug this gap. Why is it important is that all the discussants did say, and one of them put it very beautifully, that, and this is something that we all know, that neuroscientists have told us, that 80% of the child's brain formation is in the age group of 0 to, she put it 3 and I would put it to 0 to 6. Now, if you miss out on that group of people, we have a serious problem. You're not going to have them, get into a proper education system after 6 years. It's difficult. So that was something that was brought sharply into focus. And this was the point that Ms. Devika Singh brought through very clearly, she was right when she said that 0 to 6 have no voice at all. But what was more important, which she brought out, was that we need to have a framework, and we should know what we need to put in the framework. See, you go and tell the legislators, we want, children of 0 to 6 to be covered, but what do we want for them? How do we want to get it done is something that she did bring to the notice of the people in that room. The other important point which came up was, what do we do about children with disability? There were several points made. Ms. Anand made some points on that, Shilpa Anand. And, but Dr. Shivan also. But the criticality of that part of the discussion was that you need to speak about inclusion and inclusion. And one of the major points that got brought up was, like in certain jurisdictions, not within India but outside, where you have funds for people who are differently abled, you should move the funds with the children. Now that's something that we could look at, and is something that we could sort of carry forward. Importantly, and this was something that I need to sort of again go back to, is when we were discussing, my friends were not there yesterday, is about, should we go to courts at all? Professor Dhanda did give her point of view, and she did explain as to why she said that not for everything we should go to court. And Niranjan today brought it out very well, and she was a little tad disappointed with him that this was not what he said yesterday he should have. But he did make up for that. And it made a lot of sense when he said that you should actually start at the grassroots level, where you must have petitions. You should start at the panchayat level. You should go to the block development officer. Then perhaps use the legal services authority, which is something that the superior courts monitor very closely today. The important thing was, what Niranjan said was that it is the judge at the lowest level in the judicial hierarchy, not that he's any less than where we are, it's just the service that puts him there, that he is able to get these things done faster, because as far as the high courts and the Supreme Court are concerned, they have very little interaction with the executive. It's the district judge who interacts with the district collector, he interacts with the BDO, and since they have to interface with him, they listen to him very closely. So if the, as we have in Tamil Nadu, a principal district judge would say, we don't have toilets in the school. What are you doing about it? Immediately the district collector would get into, he'll sort of do whatever is to be done, given the resources that we have. So that was something that was brought out in the discussion. And then if it doesn't happen there, you take it to the next level, which is the High Court or the Supreme Court. The important thing is that it also creates actionable material. That means the High Courts often ask, and there are some who are more than willing to do it, even if you've not gone to a lower court. But there are others who are conformist, who would tell you, did you try alternate means? Is this the last resort? So we have all kinds in our tribe. So to get over that difficulty, I think it is a good idea that you must have these petitions on the file and say, listen, I've been trying this for the last 10 years, nothing has moved, or whatever span of time. So therefore, you need to look at that. Now, another area which we brought up was children in conflict areas. Now, this is something that we asked Professor Shanta Sinha to talk about, and Ms. Anita Rampal also spoke about it, is that the methodology which is followed, or the problems that you have, are no different in urban areas or cities and towns as they are in conflict areas. But what was brought to our notice was, when you engage with children in conflict areas, you need to develop trust with people you work. So typically in Chhattisgarh, you would be working with the Maoist, you would be working with the police, and it is your neutrality which helps you achieve what you want to achieve. And sometimes you have to partner with one and not at the cost of the other. So as long as you tell both major participants in this process that it is the children that you are focused on and not on the politics of the area, you'll be able to get a lot done. Importantly, what of course was briefly touched upon by Ms. Rampal was the problems that we have even in the manner in which the RTE is implemented. And she, something that I didn't know, I don't know whether Justice Muralidhar knows, that in Delhi, we have the Delhi government having, segregation by having students put in 3 slots. That means the most talented one are labeled as Pratibha students. The less talented ones are euphemistically called Nishtavadis, or whatever. I'm using the word Vadi because everything's now about Vadi. And those who've not succeeded are called Vishwas. Now, these are all euphemisms. I think you need to bring it up, challenge it, and maybe something will get done. So this, and of course, the last but not the least point was, which was the issue of should we have, because children grow up with these conflicts in their mind and they don't know how to, sorry, just 30 seconds, is should we have child mediators? And I think that was a suggestion, child mediators, and you must have children resolve their own disputes. So thank you very much, and God bless you. We had a great session.
Thank you very much. I think all the chairs summarize the discussions in their respective sessions, which were so nuanced. And I think it's very fortunate that the organizers also had judges and a professor chairing these sessions, because it quickly encapsulated all that had happened in the last 2.5 days. So I think it's a great thing. We have about 10 minutes now for questions/comments. My request would be, if it is a comment or a question, please keep it pointed and brief so that we can have at least 4 or 5, and then we would give all the chairs a minute or 2 to respond. So, yeah. Can we begin with you?
Be it land, be it education, be it work, be it health and housing. These are all in concurrent subjects. So whereby this is leading to plethora of acts and sub-acts and interpretations, making the life of the claimants, miserable, knocking every door of the department. And there is no congeniality of the procedures, and there is no synergy in the methods, that they evolved in ensuring the rights are properly realized. That is one observation I just wanted to make.
Just wanted to thank you for all the panel presentations that really gave us an idea of, maybe I'll use that. Thank you. I just wanted to add one discussion point that came up in the education group. One of the things that we really discussed is, if we are really talking about legislation in the country as a whole, particularly in education, a majority of our children and young people are disadvantaged, are coming from the disadvantaged sections, for whom there is seems to be a tendency that, they are dispensable, they don't have to be invested in, they can do with whatever is available. So I think that seems to be the state tendency in closing schools, not implementing RTE, not taking up ICDS, the Child Labor Amendment Act that we saw recently allowing families to employ children. So I think there's a plethora of acts and amendments that end up in this kind of a process. And somewhere we were also feeling that, we can demand things within the already given framework. The RTE is a framework, we demand on that. But do we also demand from the community side? The community today is saying that we want higher education. We want employment. We want to move forward. We want to be equal. So what is that framework that an enlightened group like this can really create and build upon? Because it's not possible to just build it up from one section of people, and most often it ends up being the marginalized asking for these. Like, we always talk of Article 45. We never talk of Article 46, or we never talk of Article 29 and 30. So why is this kind of a blinkers that we are building in, and how can we break that would be one concern.
Thank you. Yeah, Neha?
I would just like to make a small suggestion, and because everybody is here and happen is that when we talk, a lot of laws use the word workman. Can we start a collective effort to change it to workers? Because that also kind of penetrates our conversations. So it will not just make it gender inclusive, but take the fight a long way. So, yeah.
I completely endorse I'm the chair in the National Law School. I completely endorse Justice Raju's suggestion that we need to engage with the court. But the question is when and how. I think probably that's an important thing. When I have two important questions. Nowadays it is increasingly happening. All the policy issues are coming to the court, and court is, sometimes particularly I take the example of the long wage policy. The kind of verdict given by the Supreme Court has led to very increasing kind of privatization, mushroom growth of private school, and in turn it has in a big way destroyed the public education system. So how do we address this the legislature and the judiciary kind of things? And one submission to all the panel members. Like after establishing the Permanent Justice Committee in the Supreme Court, things are really happening in a very meaningful way. Can I make a submission whether we can have a similar committee on welfare education, because this is an important piece of social legislation, and certainly I hope that such committee will bring a very remarkable changes, at least in terms of implementing the schedule attached to the right to education. This is my sincere submission.
Thank you. I think we have time for just one more. So maybe Dr. Dhanda.
Yeah, this is just a concern that I want to share after listening to Justice Shakhtar said, don't give up on courts. It's not a well-formulated question. It's just a concern that there is something called the spirit of the times. So in the contemporary situation, the worker and the collective voice of a worker is somehow seen as anti-development or anti-growth, or whereas it is the entrepreneur, the startup man who is actually pushing the wheels of the current regime or the current system. Now, in a scenario like that, sometimes it's not that judiciary has not given good social justice, to promote social justice, good judgments. But then, how do we keep that faith in the judiciary and not give up on courts? Where does the social justice paradigm come into that whole establishment?
Thank you. If I can just make a request to everybody here, a minute, because at 12 the next session will start. So maybe we can begin with you.
There were no questions on land and housing. Or you want to say something? You want to say something?
Okay.
Huh? Oh yeah. You first. Doesn't matter.
Okay. Just one or two responses. On the fact that a lot of things, including land reform, are apparently concurrent subjects, and that makes it very complex for the poor to get their rights. It's clearly, it is a problem. It's not a problem you need. The central point that a lot of people made is that the rights of marginalized groups are often largely ignored, where there are characteristically a number of ways forward. The first thing is that those marginalized groups need to get organized and often want to get organized and are frustrated. Malcolm X said it's the door that squeaks. When the door isn't organized, it can't squeak. Whether you negotiate or go through the courts is a secondary question to whether you're organized as a group. And the collective bargaining is highly relevant. Finally, not giving up on courts. Again, I remind people of what we heard earlier about cases where litigation concerning the rights of the poor in land and housing has been held up for 15 to 20 years or more. Clearly something has gone wrong with the process. Before one says, put even more burden on the courts, something needs to, I have no idea what. As I say, I'm not a lawyer, but before you put more fish into this pot, you've got to do something about the size of the pot.
Justice Muralidhar?
Yeah. Just to say that you engage with the courts not just about reaching the end of a litigation, but as a part of a strategy for realization of rights. So you may not be clear whether it's an area of policy or area of law, but when you go to the court, you articulate what your problem is. You may get a response, which you may not otherwise get if you went through the RTI route. So you would know where the state stands, where another competing interest stands, and where the court stands. So from my personal experience, my failed petitions have taught me more than the ones I've succeeded in. So every time I fail, I learn in that process. And I leave it to a succeeding litigant or group or a lawyer to learn from that experience and to see how you can, do a better, have a better shot. And what Rajiv said, that when a high court dismisses a petition, let's say, or a subordinate court dismisses a petition, the court to which the appeal is carried will have something to react to and reflect upon. We ourselves find that the quality of petitions improves from court to court. Even the lawyer is, in a better frame to appreciate what the core issue is. So I think this engagement with the courts is an ongoing process which has to happen, because these are constitutional courts. These are issues which affect rights. So we'll have to constantly engage with this. And as long as there is a void, people will come to the court. The court can drive the policy, maybe. The court can drive the law. Right to education is a classic instance of the court driving the law. It took a long time for the parliament to respond. But it helped. The fact that sexual harassment at the workplace is another classic example. So the court does play a very, very important part in this whole engagement with the right.
Thank you very much. Justice Baxi, brief comments.
Firstly, with regard to the multitudinous laws of varying nature. First, we today are seeing a unification because the funds on social benefits are essentially flowing from the central government. Like Manrega is a central legislation. We also had a discussion on the social security legislation which is in the offing. That's again a central legislation. I'm talking from the premise of right to work. I've just been prompted. Right to food is another central legislation. So we are seeing a shift in particularly social security domain, social legislation domain, where although they are concurrent rights domains, we are seeing a more predominant pan-Indian role, both in legislation as well as in policy making. Coming to the role of courts, India's experience in social legislation, environmental legislation is judge-centric. Hardly have legislators responded to social needs so quickly as judges have done through the process of judicial legislation in unoccupied fields. My case is here. If the legislature speaks, we keep quiet. But if the legislature doesn't speak and there's a crying need to actuate rights, we speak. The example, and I would just bring in one example which was very relevant in right to work. There was a question that where is the synergy between collective bargaining and work? Very recently in 2015, 2015, the Supreme Court struck down a bylaw of the Maharashtra Cine Workers Association, which was gender discriminatory with regard to makeup artists. The Supreme Court used the the directive principles of right to work, along with Article 21, to strike down hire and fire rules under a contract of public employment in Brojonath Ganguly and DTC Corporation cases. So we have situations where the courts have stepped in. We are yet to see, because there was a discussion as to public posts being kept vacant and casual employments being done under the guise of filling up the post. Till today, a court has not issued a mandamus to fill up a post. We are to examine and explore those areas.
Thank you very much. Justice Shakhtar, no?
Thank you. Yeah, I don't want to, sort of go over this point again. Three friends have done it, and I don't want to appear to the audience that all of us are defensive about it. We are not defensive about it. All that we are saying is, it is an avenue. Please explore it. And just a quick point, Professor Lipton said, there is something that has gone wrong. But if you look at the Indian courts and you look at the courts in Britain and America, when we speak to our counterparts, they actually fall to the ground when they know that we deal with about 60 to 70 cases and perhaps more on a given day. So, what we do in the court today is, it's like a government hospital. And we pick up the cases at that time, and I'm talking about working judges. Who needs surgery first? Who needs surgery first? So, that's the way it is. Now, insofar as Niranjan's point is concerned, should we have a committee for right to education? According to me, as it is, it's a problematic area where some say, why are judges getting into administration? Now, I've told my group where I was discussing that this was pursuant to a Chief Justice conference, that we decided to have juvenile justice committees in all high courts. Now, my suggestion to you would be, seek for increasing or enhancing the ambit of JJCs and bring in education explicitly within it, rather than have another committee and have more confusion. Thank you.
Yeah.
Only one line. See, all of you think about the problems that you face in courts. You don't think about the problems that we face in courts.
Thank you.
Please start looking at it from that angle.
I think we need to thank all our chairs who summarized that rich discussion and then kept to the time. So thank you for all of them. And now from the conference organizers, a felicitation.
That I want to make, both when we talk about the failure to realize, imagine and realize, and I will underline imagine, social economic rights, and the crisis that we face, this double whammy of hatred against minorities and market fundamentalism, are ultimately, at the core, rooted in profound failures of solidarity. And I think that I really feel that we need to talk more and more about the ethical frameworks within which we have to have these discussions. Solidarity, there are many sibling ideas to solidarity, the idea of public compassion, the idea of caring, the idea of empathy, the idea of belonging to and with each other, the idea of fraternity. And I know there's a problem with the idea of fraternity because it talks about brotherhood, but we're also talking about equally about sisterhood, that we are brothers and sisters. The homeless person who's sleeping on the street, the child who is working in a dhaba is as much my child. When Junaid was killed so brutally on a train close to the place I live, I wrote an article saying Junaid was my son. I did not know him when he was alive, but in the manner that he was killed, I mourn him like he was my son. And I end by saying he was also the son of those who were traveling with him on that train. And yet we let him die. So the idea of sisterhood and brotherhood, the idea most of all of love. And I think that it is what we are witnessing today, whether we talk about social economic rights or this global crisis of hate and of the failure of the economy to fulfill the aspirations of young people for decent work, we are witnessing ultimately a failure of solidarity and love. Let me illustrate this in the little time that I have. Akhil Gupta, an anthropologist, asked a question: how many people die in India of completely preventable causes? And he came up with very conservative estimates. He estimated 2 million people. To put that figure in perspective, the number of people who died in the Great Bengal famine was 3 million. So what we are talking about is that we are seeing the equivalent of the Great Bengal famine happening in our midst every year, and we don't even notice. We talk about infant mortality rate, but don't acknowledge that we are talking about children being snatched away from their parents far too early only because they are too poor. When we talk about malnutrition, we don't acknowledge that we're talking about children's bodies and brains not being formed simply because they haven't been given enough to eat. When we talk about child labor, we don't acknowledge that for our children, we dream that they should touch the skies. But for the children of people of a particular caste, it's all right for them to labor, because that is what they are destined to accomplish. Myron Weiner asked, why does India not make the necessary investments in elementary education? And he comes with the answer, finally, it's not because we don't have the money, it's because the poor and the lower castes don't matter. And I think that is the central crisis. The crisis is not that we don't have the resources. Each of those 2 million deaths are today entirely preventable. We have 70 million tons of grain rotting in our food grain in our warehouses. Jean Drez was explaining to me what 70 million tons means is that if you put those bags of grain in a line, you can go from the earth to the moon and come back and circle the earth a couple of times. We have that much grain, yet every third child in India is malnourished. Every third malnourished child in the world is Indian. And in the National Advisory Council, I was convening the working group on the right to food. And I was seeing the enormous hostility of the entire political establishment except the left to the idea. And, when we were debating it finally in Parliament, and we had a watered down law, but it was still significant. We're talking about 800 million people getting half their calorie requirements almost free. 120 million children getting free school meals. It was it was the largest legislated social protection program in the world. And there was so much fury and television debate after television debate that week, I remember. And in one, an industrialist, otherwise very well respected, turned to me and she said, I can't bear it. Why? I have worked hard to make my money. I've done nothing to harm the economy. Why should I be taxed to feed the poor? And I think at the heart, she was explaining what the crisis today is. Why should I be taxed to feed the poor? India has one of the lowest tax to GDP ratios in the world. Much of that is indirect taxes. GST is also indirect taxes. We are not taxing the rich, and we're taxing them too little. And that is why we don't have the resources to send every child to school and to provide healthcare. The imagination of what life is. We see homeless people. I remember the time we created the first shelter for homeless women. I asked them what has changed most in their lives. And a woman said, for the first time in 17 years, when I close my eyes at night, I am sure that no one will rape me until the morning. For the men in this room, I don't think we can even begin to imagine what life would look like to you like this. But even for the women, one act of sexual violence and it scars you for life. What would life look like to you? If every night you slept, you would be raped, and there's no police person who's willing to listen to you. There's no one you can go to for safety. Working with hunger, I remember this conversation with a group of Masahar women who said the most painful lesson of all that they have to teach their children is the lesson of how to sleep hungry. And I was thinking about what life would have looked like to me if I had to teach my daughter the lesson that I can't help the fact that 5 days, 10 days in a month, I will not have food to give you, and you'll have to learn to sleep hungry. At a time when we have as much grain as that we can go to the moon and come back. So I think that we need to recognize this profound failure of solidarity. I think when people will write about these times a century or two later, they'll say, what an extraordinary world that was, that had unprecedented levels of wealth and yet allowed suffering to this degree, and why. So I'm saying that social economic rights are important, and we must legislate. I've spent much of my adult life fighting for laws and policies. But I'm recognizing now that you might have the best law and policy, you might have the best judgments, but if you don't believe that these are part of a just and humane society, they will not happen. So we have the food security law, but it's not being implemented. We have the right to education law, it's not being implemented. I'm not arguing that these are not important. I think they lay a moral standard, they give democratic instruments for struggle, they put some pressure. It would have been even less if the state didn't have these laws, but they're not implementing them. And I think, the big realization that I have is that a just and caring state can only be located in a just and caring society. I did want to, we are talking about social economic rights here, but for a moment I did want to talk about the other aspect equally related of the crisis, and that is the crisis of hate and fear that our minorities have to live with. We took out a Karwan-e-Mohabbat, a caravan of love, to respond through the month of September. Why was it necessary? I found that across the country that I was traveling, Muslim brothers and sisters would tell me that they feel a sense of fear every day. We've had communal violence earlier, mass violence, but those were limited by geography and by space. They had a beginning, they had an end. But with lynching, the message is that if you belong to that identity, you're not safe anywhere at any time. You're not safe in your own home. You're not safe when you're traveling on a train, walking on the streets. You can be attacked just because of who you are. And it has entered into their souls. And I also found an extraordinary silence of the majority community. And I felt that we needed to both communicate solidarity visibly, publicly, and therefore I said we will go state after state and visit families affected by lynching and say, we are sorry. I'm seeking forgiveness on behalf of all of us for this country that we have made, which has led to this happening to you. And to make a call of conscience to the majority community. We found pervasive hate. Assam, where we started off, two young boys going fishing in a neighboring village. Somebody says that they are cow thieves. They're lynched to death, but the body is received with their eyes gouged out, their ears cut off. The family doesn't understand why and where is there so much hatred. You film. Most of these lynching attacks have been accompanied by lynching by television cameras, where the lynchers actually record what is happening, upload it on WhatsApp as evidence, both as a lesson to that community and as evidence of what they see as their masculine valor. So I think what troubled me most, and I was telling friends that after this caravan I feel obsessed. I can't think of anything else. I am obsessed by the degree to which hatred has spread. Modi didn't create the hatred, but Modi recognized that there were aquifers of hatred in our hearts which we had not recognized. All he has done is he and Trump dig tube wells deep enough for these aquifers to emerge. But they exist, and we never acknowledged it. Noam Chomsky said about social protection is ultimately the idea that we should take care of each other. And I don't think I have a better definition for social economic rights. Social economic rights is basically founded on the premise that we should take care of each other. And I think it is that idea that we need to claim. I can't even say reclaim because we've never had that idea. I think we need to claim that idea. We have to bring love and solidarity into the center of the discourse. We'll have to fight the state. We have to fight Modi. Modi might lose the next elections, but I don't think, I'd be delighted. But that's not solving the problem. Mr. Trump might get impeached. That's not going to solve the problem. The problem is that they have exposed, the hatred in our hearts, and therefore we have to battle the state. But I think first of all we'll have to battle ourselves. We'll have to battle the demons that we have within ourselves. We'll have to recognize why I don't care when I drive out on a winter night and I see a child just my child's age sleeping on the streets, probably will be raped in the night, may have found her food in a waste heap, and it doesn't trouble me for a single moment. I'll have to ask myself why. And so our battle has to be first of all with ourselves if we have to accomplish a world where preventable suffering, eminently preventable suffering from the failure of social economic rights it comes to an end. Thank you.
Address the consequences of the war. Not only the government, but also the Tamil polity or the minority politics itself seem to be giving priority to address the consequences of the war. Sort of, generally speaking, the transitional justice mechanism, they want to, the parents of children who had gone missing or spouses of the partners who had gone missing to the war, they want the government to tell them where they are or what has happened to them, or allegations of war crimes which has to be addressed, these kind of political issues. But those are necessary. I'm not saying those are unnecessary. In order to prevent recurrence of conflict, addressing the past injustices and atrocities have to be addressed. But my point has been, parallelly, we also have to work on economic development, social reconstruction. We have to look within ourselves and within our community itself where we have gone wrong. After the conflict, there are old wounds, intra-community old wounds are cropping up. For example, caste. For whatever reason, during the conflict time, LTT had banned the caste, but it's not because of the banning of the caste system, but because of the so-called common enemy people. The practice of caste discrimination was much more subdued during the time of the Civil War, which has now re-emerged. Of course, it's not that bad as India, for example, like that. So I've been asking the civil society or the administrators, political administrators, we have a provincial council and all, to address this kind of thing. Gender discrimination, nobody wants. Even in terms of economic and social rights, there's a lot of interest by the national trade unions. All this trade union movement have been disseminated during the conflict by both parties, mainly by the LTT itself, because they wanted monopoly of power. They don't want any competing forces to take over the space. So now we have to reconstruct the entire labor movement. There are a lot of interests from the national trade union movements to the international trade union movements. But we have done mapping exercises and surveys among workers in the conflict-affected areas. Unfortunately, the workers themselves are not much interested in collectivizing, because perhaps for fear, variety of reasons, because they have endured so much of violence or trauma, they don't want to undergo anymore. They want a relatively peaceful thing. They think things are relatively peaceful now, they don't want to disturb that. So these are put in the back burner. It's not only the people themselves, even civil society as such, we also have failed to mobilize them to parallelly. Of course, everyone can't be talking about constitutional reforms. There are experts, there are members of parliament from the Tamil areas who are working on these issues with the central government and other stakeholders. but parallelly, my argument has been that we also have to focus. Even this provincial, at least the provincial government, nobody wants to touch that. Everybody wants to. There's a phobia of victimhood, unfortunately, what I call. We want to continuously be seen as victims, by and large. Not myself, but by and large, the community still feels that we are victims. So we are still awaiting justice, not only from our government, but even from the global bodies like the United Nations, which they rightly or wrongly feel that has failed to stop or mitigate the impact of the final stages of the war. So even for reparations, here, one of the transitional mechanisms is reparations, yes. Nepal has got a commission or committee or whatever, but even they're not asking for that. The one or two things, two prominent things, even today, 9 years after that, for the past 9 years, two critical things which the civil society or the vocal sections of the committee is focusing is on missing persons and so-called the political prisoners. To be fair with the government, I have to say there were about 12,000 LTT surrendees. Almost more than 11,000 have been released. But of course, there are about 600 to 1,000 what they term as hardcore, highly trained, quite dangerous ex-combatants, which sections of the even judiciary is fearful to release them. So the preoccupation onto these two very restricted areas is preventing economic and social development as such. So as a social scientist, I have been trying to do, and coincidentally, our chief minister is a former Supreme Court judge, some of you all may know. He himself, we had the impression that he's from a professional, apolitical background. He may be more open for multiple paths to reconciliation and peace, but rather he's also bogged down, perhaps due to the influence of the diaspora or whatever, bogged down into these two core issues, always talking about finding out the missing persons, and also release of these two political. I'm not saying these are unimportant, but I think we have to go beyond that if we have to seriously emerge from this devastating war. Sorry, my time is up, so I'll stop here. Thank you.
Was the only presentation we had from Sri Lanka. Maybe we should have had some more time for it because I can see that everyone was keen to hear more, but we...
Well, it's been incredibly rich conversations last 2.5 days, and conversations have a good quality about them. They never, ever finish. They always mark a beginning. I'm very glad that Amita and her team organized this. I'm very glad that they did not, and I'm very glad particularly that for distinguished, I was about to call you eminent justices, I tell you why I won't call you eminent, apart from the NJSC judgment, which does not like the category of eminence in collegium. But 4 eminent justices, one of them spent a lot of time yesterday with you also, and today Rajiv Sektar, and others. 4 eminent judges have interacted and brought to the rest of us what these conversations were all about in 4 important areas. Eminence, when I went first time as a Vice Chancellor to some, I'm not a recidivist Vice Chancellor, I don't make a career out of it, but I was called, jurisprudence embarrassment is all that we practice, can practice. So I went there by students of embarrassment. And Justice Krishna Iyer then wrote me a letter saying, I'm glad you have become an eminent person, but may I remind you, as was wont of Krishna Iyer, he always added a flourish. And he said, may I remind you what George Bernard Shaw said about eminent persons. The more eminent a person is, said Shaw, the more she has done things to be ashamed of. So I refer to distinguished people, not eminent people. I myself have done a lot of things to be ashamed of, but not in the sense that the chair of today yesterday spoke about me too, and him too. Anyway, regardless of that, I think both the preceding speakers, and my time begins after that, please. Preceding speakers, the Harsh pointed out a very poignant picture of India, the other India, where death is the only way of living, or living death greets you, no matter what the Constitution says, no matter what social action litigation says. And he referred, among many other things, poignantly to two IMRs. IMR 1 is infant mortality rate, which we have somehow controlled, but not quite so, unstantly. We have a long way to go. And IMR 2 is infant mortality rate of new ideas, which governance consists in administering death to new ideas. And we too, our learning consists in giving death to ideas, a massacre of ancestors. We don't know who preceded us. The world began when we began to think, or our computers began to think for us. So, new ideas, for example, we had somebody called Jayaprakash Narayan, who happened not too long time ago. Not a single law school teaches total evolution. There's a man called Vinoba. He had a jurisprudence. Nobody teaches Vinoba. And not to talk about the old man. Who was he? I don't use the last name because it's politically very ambiguous. Gandhi. I don't use the second name because the second name was taken by Delhi Doordarshan. Espionage serial, Karamchand Jasus. So I'm used to his first, only one name, that is Mohandas. So you know Mohandas. Mohandas happened, by the way, in India. There are lots of people happen, but we administer death to them in our teaching, our thinking, our being. So what can we do? So, and from IMR 2 is growing as a pace. IMR 1 can be controlled. We, however, operate a genocide sector quite shamelessly. And we call it planning, or now Niti, doesn't matter what name you adopt. We all are middle-class Indians, including Harsh. We try to do our damnness best, and I want to apologize for this term. We try our damnness best to ameliorate the situation of impoverished, but we who do that are very few. And even those that are very few have to exist within a permanent genocide sector. And therefore, whether it's a civil society or an evil society is something I leave you to ponder. 70 years is a long time. Not very long in the eye of history, nothing at all. But I distinguish between the eagle's eye point of view and the worm's eye point of view. According to worm's eye point of view, it's here now that matters. According to eagle's eye point of view, the soul, the flight, the vision, the constitutional vision, the preamble. So there is a difference. And when you look at the worm's eye point of view, the problem of survival is extremely urgent. It is not, it's so urgent that everything else pales into insignificance. And we because we are class-bound teachers, we also rarely think about it. So thank you for bringing this. Thank you, Dr. Muttukrishna. I represent the other side, namely of societies torn by civil war and conflict. And societies that are searching for new ways to live together and finding it distressingly impossible. And what can law, social movement, or social theory can do about it? This is happening next door to us in Sri Lanka. We have so many problems. Unfortunately, we look at our own level. We don't look at what is happening in Bangladesh, what is happening in Nepal. We look at America. Who says we are Americans, these guys. Anyway, regardless, the middle class people don't look across, not the 7 seas, but 1 or 2 seas that separate Bangladesh, Nepal landlocked, but Sri Lanka. So that's the problem. And the situation in Sri Lanka is extremely tragic. Their meaning of genocide is lived differently than in India, even today. But there are commonalities in both all SARC societies. Namely, they all operate and survive on running and sustaining a genocide sector. And it's time that so-called civil society rose up as one and threw away their class up and caste upbringing to fight these evils. Now my time begins. This was about just foreplay, but important forward. Now, essentially I want to talk about 4 things, or 3.5 things, depending on what time I have. Amita asked me to talk about a peep into future. I'm not a futurologist, although I've written a book called The Future of Human Rights, and that can be summed up in 1 sentence. That book, a book must be capable of summation in 1 sentence. That's the important thing about a book. And I think a book entitled The Future of Human Rights says that human rights have no future. And this is again borne out by what the 2 distinguished predecessors and all of you said today, on yesterday, and day before. So, I'm not a philologist, but I would speak about future of social economic rights, or future human futures. Secondly, I want to talk about a little bit about who are we? The NGOs, and I believe the NGOs cannot exist, as I said the other day, with NGIs. You know NGI? NGI is non-governmental individuals. I'm here. And NGI. And NGOs hopefully are comprised of NGIs, but not always they are comprised of NGIs. There are various kinds of NGOs, which are studied. Anyway, the third question I want to look at is the question of responsible criticism. And I requested Amita to circulate the paper or send it to you. She would do it. I won't speak largely about it, but it is a very recent paper of mine. And it's on social action litigations. When you have time, you kindly look through it. The fourth theme I want to discuss is the question of how to organize negation. These are 4 areas I want to touch, and wherever I have to end, I'll end and imagine the other areas that are left out, that I have not presented. I try to present them. 1, on the question of we discussed judicial activism, and Amita very kindly said conversation, not a symposium. Symposium in original Greek means drinking together. But Nalsar is a very dry place, I understand. Not intellectually dry, but otherwise dry. And you go to great distances to drink. Those who live in the hotel might have a different experience, might have it at a symposium. But those who stayed here would not have the opportunity for liquid diet, let's say. So when I went to Ahmedabad, Surat, as they were in office in the university, I was asked to meet, I met the governor. At that time there was B.K. Nehru, the governor, chancellor of South Gujarat University. All governors are ex-officio chancellors. And he lectured to me about being on the wrong side of debate on judicial activism, B.K. Nehru has written several articles against judicial activism, and partly discussed judicial activism only because he differed with me, but because also I did not cite his articles. Very often this happens. And B.K. Nehru lived in a place called Gandhinagar. And I asked Nehru, I said, aren't you ashamed living in Gandhinagar? What was one thing about Mohandas? He was itinerant. He always moved. Gandhinagar is one place where there are 6 or 7 gates to the city, and they can all be closed so that people, actually existing people, do not come inside the city if the governor so wishes. Imagine the paradox of being where you have a right to freedom of movement, also we are taught in Constitution, association, and you plan a capital of a state. Now, whether Gandhinagar has become, all Indian cities have become Gandhinagar or not, I do not know the geography of that, or the politics of that. But the idea was to exclude as many people as possible in cases, in times of governance. And that is probably what not our Constitution says, but that's what the governors say. But I also was asked, and the first and last time I met the Chief Minister. The Chief Minister then was a man called Mathew Singh Solanki. And Mathew Singh Bhai, well, Gujarat is, he says bhai and ban. Bhayo Bano. So we said, Mathew Singh Bhai asked me the question. He said, you are a student of constitutional law. Can you tell me whether this court should interfere in administration? And his face beamed when he heard the first half of my response. My first half was, the court should never interfere in administration. And he thought that was the all of the sentence. I said, no, please listen, let me complete the sentence. Court should never interfere with administration, comma, if any. Social action litigation, there is no administration. What will the courts do? What the High Courts and Supreme Court have done, if you look at administrative law, if you look at constitutional law and other decisions, they have made policies where there were none and asked the executive to make a policy. Sometimes the executive did not work, so the judicial policies are being followed. When the High Courts and the Supreme Court of the country have issued all kinds of mandamus for rickshaw pullers, for those marginal people, for rainbasara people, for all kinds of mandamus. And why? They have become, the judiciary has almost ceased to be a part of the state in India and has become a part, acquiring the attributes of a social movement, a new social movement. Whether they succeed in their mission is a difficult thing to say, but that's what they are endeavoring to do. And they are using the Constitution and its values and goals, as well as the statutes which further them, as the basis of judicial action. So all this talk about judicial propaganda, believe you me, is pure propaganda. It's no basis on facts. With all the work, noble work the courts are doing, I have statistics for the Supreme Court, I think they'll hold for most high courts also. Less than 3% of the volume of the work pertains to social action litigation. If that is the case, how can you say the social movement people and the activist judges are clogging the court with all kinds of petitions? It's pure propaganda, as far away from facts as it can be. I studied the matter, so take it from me. The social action litigation takes a very small part, infinitely small part, and yet its reach, its newsworthiness, its social impact is massive. And that I've discussed, that's why I call it social action litigation, not public interest litigation, because it's done in partnership with social movement and progressive elements in civil society. And I will elaborate that, whereas the public interest litigation also occurs in India, gradually. The court determine what is in public interest. The Delhi High Court, unfortunately, for example, passed a series of orders for slum clearance and exempted. And the orders are, Gautam Ban is here somewhere, he has written on this. He had written a book, I call it not poverty but impoverishment. I banished the word poverty because my Lord Jesus said long time ago, 2,000 years and odd years ago, that the meek shall inherit the earth. I'm still waiting for that day. 2,000 odd years. Maybe it will take longer, I don't know, but that's what spiritual leaders also said, that poverty, impoverishment will continue to exist. And Gautam has written a book called Impoverishment of Impoverishment. How do you develop ways of further impoverishing the poor? And this is what we are specialists at. And that's what I told the South Africans. So they're making the constitution. I said, do everything you can, but don't follow Indian constitution. You require judges to go out of the way to nudge. There is now somebody got a Nobel Prize for nudge economics, theory of nudging. And he got a Nobel Prize. You can look up that Taylor or somebody's name. The judges nudge executive, legislature, so action. All the time an activist persona goes in nudging them, making them do things that it is their duty to do. So I think social action litigation has come to stay. We, all of us here, outside, we question, or before I come to that, I'll come to anthropology. Who are we to question courts? Who are we to question the executive? Who are we to question the legislature? Now we have a number of answers, but all the answers boil down to saying one thing, namely, they do not do enough for the people. The question still survives, who are we? Are you representatives of the people? Well, obviously social movements are not political. They don't run parties. So they are not representative. Who are we? And that's a critical question that every activist or a group of activists must ask every day. Why should anybody listen to me? Not complain that we are not being listened to. I believe activism is very high, hard work. Not only high work. It lies in the way in which you exploit a contingency and make this into an affair of rights. It is not easy. I've done a lot of work myself. It's not easy. And increasingly it is becoming more difficult by the way competitive power politics works in India and has worked in India. So I think we can dream of ourselves as new sovereigns or non-representational political actors. They're very nice words, they're enormously nice words. The activists are new sovereigns, they're civil society. Which civil society? Tata, Bella, Mani and Rani are also part of the civil society. It is civil society which practices exploitation. It is civil society which practices untouchability. So we are not representing civil society at the market. We are not representing civil society at politics or economics. We are not representing necessarily Varna Vyavastha. What are we representing? Somebody would say human rights. I think whatever we are doing, we must ask this question, who are we and why are we? And why should anybody, any policymaker or decision maker listen to us? I think that's really important as a way of introspection. I skipped the first question. The first question I had to face was future. And I said, I have no crystal ball in my hands to gaze. But I do know that we are living in Anthropocene. That is global warming and climate change. And we know nothing about Anthropocene. That will not do. I think we are doing as activists, what we're doing is wonderful. Child rights, housing rights, workers' rights, wonderful. May God bless us all if they exist. I'm a godless chap, so whoever the power is, it exists doesn't matter. I don't want to go there. Point is, we are doing wonderful work. But that wonderful work is now threatened all over again by what is called Anthropocene. We are living on the edge of extinction of the planet. This morning I got an appeal from South Pacific Islanders asking for my signature, and if you get it, I request you to sign it. As I talk, as we discuss this better, few islands are going below the ocean. Out of 1,000 islands, 3 or 5 already have sunk. Why they have sunk? Because the temperature is rising. So they call themselves a climate warrior group. They are also activists. From Fiji, from Nauru, from small, micro, mini areas in Pacific. Activism in Anthropocene era is a different kind of activism than activism in the era that preceded it. The era that preceded Anthropocene was named as Holocene, and it lasted for 12,000 human years. We are now in the early part of Anthropocene. And Anthropocene and global warming arises because we put so much carbon in the atmosphere. I'm very glad for my Lord Arjun Secretary's judgment in Firecrackers case. But that kind of activism does not really address the Anthropocene. So future job for lawyers, activists, justices, and politicians is how to prevent global warming. UN has just passed, Secretary General has just yesterday said that we are living in a 3% society. What is 3%? At the height of industrial revolution, the emissions into the air were under 2%. And when the emissions in the air are supposed to rise, then obviously there is a phenomenon of disappearing state. Bangladesh is going to go down the sea by 2030. Yesterday I read out some statistics. Secretary General of the United States has said now already the world temperature is 3.3, which is higher than industrial revolution. And they have listed 10 cities which are going to go down under in next 30, 50, 60 years. So 2 generations. There is an enormous problem of climate refugees that is going to come when Bangladesh sinks. Where will the people go? What responsibilities do we have? I don't want to go. I am writing a book on anthropology. Can law and justice, can law ever be a means of ecological resilience? Can law be used to help efforts to prevent Anthropocene from advancing? I think the answer is yes. But very few people think about it. Certainly law schools, lawyers do not think about it in Asia and Africa. I don't know about Latin America and other parts of the world. So we have a duty here and now to do something about it. What will be this agenda of human rights like in the Anthropocene? Then extinction is a problem, not right to work, when right to live is a problem. And what the Supreme Court does is very meaningful. It says this is not a case about firecracker. It's a question about right to breathe, right to life. And firecracker is a minor manifestation. So it might be important for India in Diwali times, in newer times, but it's not. It is the fact that the atmosphere cannot sustain more heat, more temperature. So I've given you a rough idea. I think we have to think of what Anthropocene justice would look like. I'm very grateful to Akanksha for sending a general email today from which I'll get all your addresses, I think. I hope everybody is on it. But anyway, I'll circulate some work I've done on Anthropocene. And I hope that you'll carefully study Anthropocene activism and what it may or may not mean for human rights activism. I think this is very important to study and to make up your own mind on which way to go. This is a very serious matter. Now, two more questions and I'm done. How do we develop responsible criticism? The word is Jacques Derrida. It's a throwaway observation of Derrida, where he's saying that there should not be, he says, and I quote, shining white knights of responsibility, unquote, but response-able critics. I think he didn't pursue this theme, but I pursued it on his behalf. And I said activism in India and elsewhere must mean response-able. Criticism and critique, that bit enables us to respond to a crisis. Responsible? It's a joke. It's a joke. My friend Arun Jaitley had introduced New Companies Act, and there's a whole chapter on corporate social responsibility. In 2013 and 2015, it is implemented. Rules have come. You can't read the chapter. It's not even a good joke. It's a sick joke. How can you talk about corporate social responsibility in the land where Bhopal happened in 1984? And victims are still second generation, third generation are suffering. So it's not, whole idea of corporate social responsibility is meaningless unless affixed by certain human rights. And as you know, as the chair of the Social and Economic Rights herself confessed, and cultural rights the other day, corporations are regarded as moral free zones. To use the language of David Gauthier, who had written a book 25 years ago. Moral free zones. No human rights obligations extend to corporations and doing business. Oh, I stop there. I've got only 2 or 3 minutes, so I will now go to the third point. Anthropocene, who are we? Third point was, what kind of activism do we want? How to be responsible critique? How do we? First, I think one has to be an indignation entrepreneur. Whether you are a judge, or an activist, or an NGI, or a teacher, or anybody, political actor, you must be able to trigger indignation in society. Bureaucracy specializes in, and governance specialize in production of social indifference. And activism must combat this production of indifference by the entrepreneurship in indignation. We must be angry and harsh, and our distinguished speaker from Sri Lanka, both angry young man. I used to be angry young man, but now I'm angry not so young man. The angry not so young persons and young persons who are angry should join hands and say certain things are not on. That's what activism, as you know, is all about. But social responsible criticism must do the following things. Must understand a difficult situation, not what we expect from courts, but we must learn to know how judges think. And in India, there has been no discipline till now on 2 areas. How do lawyers think and how do judges think? We just do not know, and yet we are experts in something called jurisprudence. We are very good at fooling other people, but basically we do not know. Therefore, we could not answer your question about the stay order. how come ex parte stay orders are issued, which make nonsense. We cannot have no answers. Because we do not know how judges think. 2 more minutes? Oh, thank you. I'm finished. How do we think? So I think first thing is how do we become indignation entrepreneurs? The second thing is, in responsible criticism, is how do we organize negation? And for that, you don't have to go very much further than Baba Saheb Ambedkar, who did all his life educate, organize, and agitate. We don't have to go further than Mohandas, who said civil disobedience to power. Now we have plenty of resources, homespun. We can go overseas also and look at Martin Luther King, and we can look at Mandela if you want to do it. So you can do a number of things. But organize the power to say no to the state. The power to say no is critically important. It will be regarded nowadays as sedition, but I think even so, organizing negation is a very important way. For example, we don't want extractive industries. We don't want coal. We don't want fossil fuel. Not in my name, says the NGO movement. Not in my name. You can't do these things on the ground that you represent us. And finally, and very finally, sir, I go to a French philosopher and great theologian called Emmanuel Levinas. Levinas wrote a book, Levinas, wrote a book called Difficult Freedom. And he wrote about Israel and Judaism. He's a great Judaic scholar. And he said, state of Israel survives in difficult times, difficult freedom. I won't elaborate, I don't have the time. But he said one very important thing in that book of essays. Levinas said, we must try, I'm summarizing him, no time, to aim at foolish excellence. The opposite concept of foolish excellence is rational fools, which Amita Sen has developed. Economists are rational fools by profession. Other things, economics here, I don't mean to be personal, but economics is a science in which you have to be rational fools. Says Amrita Sen, I can't find a better economics theory than that. I don't have time. So the social excellence litigation, warts and all, is foolish excellence. At times it is very foolish and it is very tragic, like Bhopal. But most of the time it is foolish excellence. How to develop foolish excellence is a problem not just of Holocene, late Holocene, but also of the Anthropocene justice. Thank you. I'm sorry to have gone on so long. And till we meet again, keep safe.
I think on that inspiring note, that's a good point with which to close the conference and maybe have questions and discussion over lunch and continue the conversations that we've been having. May I ask Professor Dhanda to propose a vote of thanks and to close the conference.
I need it. It's okay. Thank you so very much. You know, when your heart is full, it's sort of like good to let some of it, I'm dropping things around, to brim over. It's important that it should spill over. And one of the things, or some of the two things I think, which increase with sharing, one is knowledge and the other is love. The more you share of it, the more it becomes more. And I'm sort of sharing this, I call vote of thanks as the last ritual in a way of happiness, joy, and high fives. And I've sort of come here just to do that. I want us to sort of very strongly say that we did it together. It isn't the organizers, and it wasn't the participants. It wasn't the people behind, it's not the people in front. We all did it together. So the first thing I want to, or the first thank you I want to put in there is a generic thank you. A generic thank you for the speakers, the chairs, the volunteers, the timekeepers, the administrators, the drivers. I'm going to name every one of them, but at the moment, I firstly want to start by acknowledging that each one of us, in different kinds of ways, contributed to this. I would say it was an experience for us. Hopefully it was an experience for you, an experience we want to continue with. The second thing I want to also begin with, I want to begin with the behind the scene operators. So I begin with Shruti Pandey. I begin with her not because as the program officer of Ford Foundation, she kind of approved this project and she gave us the money. But because she allowed it to grow. She did not let the proposal be a stranglehold. She let it be a kind of a guiding thing. She sort of saw the changing times and she let us evolve with those times. We were in continuous communication with her. And I would say somewhere, if there is some kind of a stereotype of a program officer, you don't conform. The second I want to sort of do is also, I have been saying, we've been listening, we've been sort of having a lot of speeches. I've made my own share too. But I think in a lot of mails to people, I had said that conversations don't happen with just speaking. They happen as much with listening. And in fact, more with listening. It's because when you listen to each other that we talk better with each other. So, but I wanted to sort of somewhere acknowledge also up front, there are a number of people in this audience who have just come to listen. I've got people coming in from HCU, from BITS Pilani, from TIS, from Symbiosis, and I got Deepa Dhanraj. And it's like, okay, if Deepa Dhanraj sees something, hears something, we will all see something tomorrow. In my introductory speech, I had made some garbled stuff on emotion and caring, and we're not going to do only rationality, we're going to do as much about feeling together. I think I was quite incoherent, but then feeling is. Also somewhere, I think I was also very nervous, and I didn't want to overstretch time. So all of those factors played, but I really do wanted a little bit unpack what I meant by that. The bags we gave you, the files in those bags, the dupattas we have, every one of them has a good, strong emotional story for us. Kritikala, who's kind of the people who've done the bags and the files, they actually, recognizing what we were trying to do, they went and sourced whole thans for us. They did that entire thing. And more importantly, they have trained a range of slum. This reason of seeing a connectedness between intellect and emotion, that we have had our program, not just of presentations and speeches and interactions, but also a street performance which appreciated the skill other than talking or also talking, but more importantly, touched our hearts and brought the child within us. The play was resonating in another sphere and through another medium, the whole issue of discrimination and non-discrimination. I'm thankful to both street performers and Ruchika Theatre Group and Faisal Al-Qazi for an out-of-the-world experience. Fellas, with the kind of expertise to do the sort of really quality of bag that you've got there, and consequently, it was like for us that yes, bags have to be given, but if bags show the kind of love and emotion with which they are made, they are actually providing livelihood, it means something. And the same thing holds good for the dupattas, which is coming from Dastkar Andhra, and it is really high moment for us to gift to the founder of Dastkar Andhra, honoring her with, in a way, her own dupatta. We've as far as we've replaced the flex this thing with the cloth banners. And Ishivani, we totally take note of your point about too many plastic bottles. The next time you come, you'll find us playing around with coolers and other things. That's where you're going to get your chai from. These conversations have been put together with people whom we knew beforehand. It's not like, I wouldn't say that it's all a collection of strangers. But there were many whom we did not know. We did not know them personally. We knew of their work, and we wrote to them primarily on their work. I want to also at this point acknowledge the fact of that Albisax, Jadres, Parages, and I'm not name dropping. I'm only sort of saying every one of them did want to come. Albisax, like typically being him, said, listen, I have stopped traveling. But he sent us all his books and his speeches and saying, this is what I can share. And please do tell me what happened and I'll want to stay connected. Both Parajas and Jadres made promises for future. The point I'm somewhere making is this key. When we talk about love and we talk about making relationships, I'm reminded of a very old Hindi film song. You say that, humse aaya na gaya, tumse bulaya na gaya. Fasla pyar ka dono se mitaya na gaya. The point I'm somewhere making is, it's to do a very rough translation, that neither could I call you and nor did you come. And consequently, that distance between love, Bilkis, couldn't be bridged. The point I'm making it for all of the organizers, and I'm supposedly lots of sorts of other conversations in other places would happen. Ye pooch lo, achhe se nyota dena. If you give a good invitation, people do respond. That's our experience, and I'm sort of sharing it. Whether it is Professor Michael Lipton, whom we did not know before, whether it was Uzrama, whom we literally called a week before, whether it's Rahul Magati, whether it's Sujata Modi, literally a Facebook post, and I requested and she came. And I think it is important somewhere that we keep a watch out for good work. We keep a watch out for people who work like us. And what is love if there is no overture? It's important. I think we should learn how to proposition in non-harassing ways, but not give up propositioning. We've done a lot of judge bashing, though of course Justice Shakdar said, not defensively, but don't give up on courts. We are not giving up on courts, I assure you. And the judges, the 4 judges we called here, Justice Ramasubramaniam, Justice Muralidhar, Justice Baxi, Justice Rajiv Shakdar, all of them are demonstrating to you that judges can also chill, carry their offices lightly, allow themselves to be ribbed, and just human. Not too many, so I'm taking a leaf out of Professor Bakshi's book and saying the good ones we should celebrate, and celebrate again and again, and may your tribe grow. It's ceremonial and it's part of, the Indian notions of hospitality. That international guests, because when it comes to international guests, all national guests join in together and we become hosts. So for the international guests, a special thank you, because it's not easy and you're coming all the way and I'm saying, okay, 15 minutes and not more. I mean, I totally, Mutuswami, it's like we could have had a whole seminar just on your work. But tasters and, like you excite people, so you go seek out and more will happen. But especially want to be thanking every one of them. So Michael Lipton, David Bilkis, Neta Zevi, John Reed, Siobhan, Biju Mathew, Virginia Gomez, Sapna Mala, Muttukrishna Sarvananthan, and somebody who's like international, national, Gabur Gombush. Thank you so much. Okay, I have a list of people who've kind of, without whom, and in fact, I think I must have said, yes, 5 more minutes, chup. I will finish in 5 more minutes, I assure you. It's like, I think I must have the shortest time of missing anything in the entire conference. I just sat through it all. And I sat through it very, very reassured that I had a large number of people, an army out there who was taking care of everything. I had student volunteers who did all sorts of things. They went to airports and picked up people. They took people for, sightseeing. They did timekeeping. They did rapporteuring. They did interviewing. They did dog's body, they did intelligent, they did it all. And they planned it. So thank you so much. Aman Muhammad, Ayush Malik, Abhishek Shah, Avanindra Khare, Balaji, Sudeep Pandey, Avinash Reddy, Ananya Krishna, Kevin Shaji, Chandi Raj, Lovishkar, Parika Kamra, Shreya Nayak. Really, really one quiet worker, ceaselessly going on. Josh Dalrymple for all the interviews that got in. Chandrasekhar Sriram, Arush Khare, Ashok Shivaram, Shrikar Acheru, Pallavi Gauri. And because I had promised TPS Harsha, I wouldn't thank him. I'm not thanking him, I'm thanking him elaborately. Also, my colleagues who had a tough time of timekeeping, Varun Malik, Vivek Mukherjee, Adya Surbi, thank you so very much. This particular conference will have, hopefully, an intelligent report for you. And the woman who's in charge of it all is Malvika Prasad. But I want to sort of thank her in advance. A lot of people from the administration, numerous kind of jobs of all kinds they have done. So I'm extremely thankful to Chidambaram, Venkateshwar Rao, Sudhir, Kateshwar Rao, Suresh Kumar, Rudra Swami, Mala Prasad, Ganesh Prasad, Hanumant Rao, Janaki Ji, Pavan, Anand, Peter, Satish, Prabhakar, Sajida, and Ramya as great assisting to Padma. All of our drivers who saw to it that we came safely and will go, Ravi, Ganesh, Mujahid, Rakesh, Anwar Pasha, Devender. The people who kind of ceaselessly saw to it that there were no issues of any kind, Suresh, Ramesh, Shankar, Jai Hind. My last set here is the IT people, Irfan Saab and his team of Pasha and Frank. Irfan Saab, of course, I think he's something like the Vice Chancellor. He is the hands-on IT head, so he does everything. If he has to pick up the camera, he does it. If he has to sort of plan a new way of getting an app for Nalsar or getting us on YouTube, you name it, he does it. I'm also quickly wanting to thank all my members of as I was doing this conference, I had a number of colleagues who took on responsibilities which ordinarily I'm supposed to fulfill. So I want to thank my entire academic exam committee for the fact that I kind of bunked every single thing, but they saw to it that I was not missed. I'm coming to the end almost, so I think I'll keep your time. I'm coming to my home team and thanking home team like Anandita, Astha, Nikita, Saurabh, Shiv, Uma, and Professor Mustafa. This is like thanking oneself, as they say. But I think it's important that in these times of uncertain affections, that you should love yourself. And I also sort of at this point want to remember and flag out, it isn't all smooth. I mean, you're seeing the ones who came through. You're seeing the ones who were like integrally part of this entire team. But we made our share of mistakes. We had, what should I say, torturous separations. We had all of those things which is part of loving. If you love, to dil to tootega. But toota to kya? That is no reason ki dil na lagaya jaye. There's no reason that just because you have heartbreak, that you should not be having sort of like, what should I say, should not be making relationships. This particular conference was saying knowledge-based interventions. So I need to go back from where it all started for me. And I know for many persons in this audience, I was taught to think, provoke, compel, think, question, and re-question, and not to be complacent. Not to be complacent with answers, but a task he continues to do relentlessly, with humor, with anger, with logic, with wisdom. अगर आप हमारे टीचर नहीं होते तो शायद हम ऐसे नहीं होते. So if I am good or bad, you're responsible for it either which way. But more importantly, he taught us to be like ourselves, not to be somebody else. At each point of time, asked us to sort of look for our own strengths. And I think possibly somewhere I am asking my students to carry on what you taught me, and hopefully my students will teach their students. I know all of you know that this conference, and I think the largest number of mails that you have got from, is a lady called Akshara. So I think we should all give her a very, very big hand. And with Akshara, also give a big hand to Padma. Thank you so very much. चलिए, हमने थोड़ा सा maybe एक आध minute time दिखाया. Thankfully, Varun was kind to me and he didn't show me 2 minutes more and time up. But I invite you all for lunch and let's continue with this bonding, have more conversations. We've got another kind of project from Ford and you will hear from us after the break. Yet, I forgot to acknowledge the one who has done this for a lifetime. She took care of the vital every day so that he could support causes, people, and individuals. And when, whilst doing it all, he had a stroke, it was her perseverance and trust which brought him back. For herself, the family, and all of us. The sharing continues. Yes, friends, I speak of Prema Baxi, who I forgot to acknowledge in my vote of thanks the other day. This is just to say, Guru Ma, tujhko salam.